Is there a way to overcome the current constitutional confusion? Isn't it sad that we're all arguing about constitutional fundamentals in Malaysia? In his Spirit of Liberty speech, a famous US judge with an unusual name, Learned Hand, once said, "If the spirit of liberty flees your heart, no written constitution can ever save you." I do not know if you realize it, some politicians have dragged that spirit of liberty to the grave in this country. The cabinet is playing hide and seek with the constitution. This has resulted in a political impasse because of the way our past leaders have meddled with it. Our federal constitution has failed us, especially at a crucial moment like this. Some months ago, I had to write a paper on the concept of legal necessity. I consulted my friend and a senior lawyer, Mr. T. Gunaseelan. This is Mr. Guna over here. Guna sent me a paper yesterday. He sounded very excited. He included copious material, so I had to wade through all of them. The ideas that are present here today originated from him and his paper. What follows is, we think, a simple solution to this grave problem. In school, when I was stuck in a mathematical problem, my teacher, Mr. Chakravarthy, used to say, "Go back to the basics." Why do we need constitutional law? A constitution is like traffic rules. It's not whether we should drive in the right lane or on the left. That's not the point. The purpose of traffic rules is everyone must be safe, no one must be injured. The federal constitution is a commitment to ensure that both individual interests and collective interests of the state are satisfied. That commitment, that purpose is called the doctrine of constitutional morality in law. What's that? It's a willingness to be faithful to basic legal values. You marry someone, you must be loyal to them. The Indian Supreme Court, for example, has invoked this in two cases. One was called the Indian Young Lawyers Association versus the state of Kerala, and secondly, the government of NCT versus the Union of India. Does the behavior of our politicians give you the impression that they have followed constitutional morality? What do you think? Now consider these 14 complaints I had made in an earlier video entitled 14 Reasons Why This Perikatan National Government Has to Go. Why keep them? So, what can the king do under these circumstances? Can he fire the cabinet and appoint a new prime minister? That is the question in everyone's mind. They know what the problem is, but nothing, it seems, can be done. Now the problem here is, unless the prime minister and the cabinet behave ethically, constitutionally, and leave on their own accord, the constitution does not seem, emphasize the word seem, the constitution does not seem to empower the king to directly dismiss the prime minister or his cabinet. You know what I think? I think His Majesty can do it. Only when someone else comes with the majority, it seems, can His Majesty the King appoint that person as the new prime minister, because the previous prime minister has lost his power to stay on by a withdrawal of support from his colleagues in the Dewan Raya. Now in my view, His Majesty may do one of two things. He can undertake to appoint a new prime minister under the doctrine of necessity, or go to the federal court for its opinion on what he should do or whether what he has done is right. So what is the doctrine of state necessity? That doctrine of necessity allows those in power, like the king, to assume power that they do not have and expand part of their limited authority to do something outside the constitution, especially during a public emergency. Would you consider the current state of affairs a public emergency? What's your answer? You're going to say no, is it? The courts do not approve of it, this concept, unless it is used for very limited purposes. For example, to restore public order or to bring about stability. So in those limited circumstances, the acts of those in power can be considered constitutional and legal, even though such an action would normally be seen to breach or contravene the Constitution. A gentleman by the name of Professor Mark M. Stavey says that power of necessity pits a seemingly meddlesome court squarely against an executive, a government, which is deeply committed to an unlawful course of conduct purportedly to save the state. If narrowly and carefully applied, the doctrine of constitution is an affirmation of the rule of law, he says, at page 34 of his paper called The Doctrine of State Necessity in Pakistan, that you can find in the Cornell International Law Journal dated 1983. Now, this doctrine has been invoked in various jurisdictions. I'll give you a small example. In Pakistan, in the case of Bhutto against the Chief of Army Staff, the doctrine of necessity is rarely ever used. Courts mostly reject its use unless specific exceptions exist, especially public order. Are our current circumstances strong enough to invoke the doctrine? Can the king use the doctrine of necessity? If so, how? In each of these circumstances, the cabinet consistently ignored and acted outside the constitution. Cabinet is bent on avoiding its constitutional duties. It refuses to be tested before Parliament. Each time it asks for more time or deviates from the course of challenge. It has shut out the voice of the people, exactly what the Dewan Rayat is meant for. And people are dying in the thousands. In these circumstances, can the king appoint a new prime minister because he has reasonable grounds to believe that the incumbent prime minister has lost his majority? In both Guna's opinion and my humble opinion, we think His Majesty can. That majority can always be tested in the Dewan Rayat, which is now, you guessed it, shut. Come September, it may be shut again. Because the Constitution allows the king to refer a question of law directly to the federal court, His Majesty the King can ask the federal court for its opinion. For example, he could ask whether, under the current circumstances, he could dismiss a recalcitrant prime minister and his cabinet and appoint a new prime minister if the new prime minister is unable to cobble together a requisite majority, whether His Majesty the King can use the powers of necessity to appoint a caretaker government pending elections in 6 months or pending relief from the pandemic, say in 6 to 9 months or such other time as may be necessary. Article 130 in fact allows the king to ask the federal court for its legal opinion on the effect of the constitution. That is what we think His Majesty should do. There is a second option. The federal court itself can act on its own motion, and in India it's called one act suo motu. What is to stop the federal court from taking judicial notice, meaning the judges can see with their own eyes the current constitutional conundrum and the cabinet's wayward, unconstitutional behavior in refusing to be tested? True, the Malaysian Federal Court has never acted suo motu on any issue. That doesn't mean that it cannot or that it will not. There is nothing to stop the Federal Court from acting suo motu by relying on the doctrine of constitutional morality as well as the doctrine of necessity. Will our judges do it? We don't know. We can try. The third option is this. What is to stop any citizen or a public interest group from writing to the Chief Justice, complaining and invoking what is known in the law as epistolary jurisdiction? There is a precedent for this. In early 1960s, a prisoner in the United States prison sent out a postcard to the US Supreme Court complaining about certain circumstances. Now, the court treated that as a formal petition in the case of Guidon versus Wainwright in 1963. 2 decades later, the Indian Supreme Court, in the case of S.P. Gupta versus Union of India in 1981, took the cue from the American Supreme Court's decision in Wainwright. It accepted a letter from a citizen as a writ petition. I'm confident the 3 proposals we have mentioned above will receive the people's support. Now, here is a nuclear option. There is such a thing called the inherent jurisdiction of the court. Every lawyer knows about it. It's a power that the courts give themselves in order to do justice. The federal court is the court designated by the federal constitution itself to answer difficult constitutional issues. Every judge in the land, when she or he took the oath of office, swore to protect the constitution and uphold the rule of law. If so, there is nothing to stop the federal court judges from calling before them the incumbent Prime Minister to prove that he has numerical support in the Dewan Raya before September and ask for arguments from all interested parties. Now, these are extraordinary times. Unusual times call for unusual measures. Eventually, if no one is willing, we have to trust our judges to do what is right. This is because, as Lord Denning once said, and it bears being repeated, every judge on his appointment discards all politics and all prejudices. You need have no fear. The judges of the nation have always in the past and will always be vigilant in guarding our freedom. Someone must be tested. Let it be the judges, said Lord Denning in his famous book, The Family Story, and there you have it. Thank you. Good night. Subscribe, share, and comment.